Visit ILMS Academy for various courses from contract drafting, RTI, labor law, GST, and more. Get certified to enhance employability.
There are three opinions. I had requested Brother Justice Surya to prepare the judgment of the court. In the meantime, I received a judgment from Brother Justice J.B. Pardiwala, Jamshed Pardiwala, in a dissent. So then I thought that's an opportunity for me to not deal with the dissent, but sort of again place some few thoughts. So Justice Surya has authored an opinion for himself, Justice Sundaresh and Justice Manoj Mishra. Justice Pardiwala has authored an opinion for himself and in dissent. The majority of us have upheld the constitutional validity of Section 6A of the Citizenship Act 1955. Justice Pardiwala has held that Section 6A of the Citizenship Act 1955 is unconstitutional with prospective effect. I'll just read out just a few extracts. The challenge to the constitutional validity of Section 6A gives rise to the following issues. A, whether the grant of citizenships to migrants from Bangladesh to Assam was within the legislative competence of Parliament under Article 11 of the Constitution. B, whether Section 6A of the Citizenship Act adopts unreasonable cutoff dates and singles out the state of Assam, thereby violating Article 14. C, whether Section 6A can be regarded to be violative of Article 355 on the ground that the provision does not curb undocumented immigration, which amounts to external aggression. D, whether Section 6A is violative of Article 29(1) of the Constitution on the ground that Assamese cultural identity is lost as a direct consequence of granting citizenship to migrants from Bangladesh residing in Assam. E, whether Section 6A(3) of the Citizenship Act is unconstitutional on the ground of temporal unreasonableness. And F, whether Section 6A(2) is unconstitutional on the ground that it neither provides a method for implementation nor empowers the executive to implement the provision. Section 6A confers citizenship on those who migrated from Bangladesh to Assam until 24 March 1971. Article 6 and the proviso to Article 7 confer citizenship on a limited class. Section 6A deals with those who are not covered by the constitutional provisions, that is, those who migrated or re-emigrated after 26 July 1949. The provision also covers those who migrated in the period covered by the constitutional provisions, but who are not covered by the substantive stipulations in the provisions. For example, Article 6 does not cover a person who migrated from East Pakistan to Assam after 19 July 1948, but did not apply to register as a citizen before the commencement of the Constitution. Section 6A confers citizenship on such persons. There is a certain degree of overlap between Section 6A and the constitutional provisions. However, that does not amount to an alteration or amendment of the constitutional provisions. This is for the simple reason that Article 6 and the proviso to Article 7 confer citizenship on the commencement of the Constitution. That is, they deal only with who shall be citizens on 26 January 1950. In contrast, Section 6A confers citizenship from 1 January 1966 to those who migrated before that date. Those who migrated between 1 January 66 and 24 March 71 are conferred citizenship upon the completion of 10 years from the date of detection as a foreigner. Thus, Section 6A confers citizenship on a later date to those who are not covered by Articles 6 and 7. Section 6A could be interpreted to alter or amend Articles 6 and 7 only if it conferred citizenship retrospectively, as at the commencement of the Constitution, which is not the case. The use of the phrases notwithstanding and shall not derogate from produce different effects. Article 11, when interpreted on the basis of the above analysis, produces the following meaning. A, the legislative competence of Parliament to enact laws related to citizenship is traceable to entry 17 of List 1 and not Article 11. And B, the provisions in Part 2 do not impact or limit the legislative competence of Parliament. Section 6A was included with the object of reducing the influx of migrants to India and dealing with those who had already migrated. The Assam Accord was a political solution to the issue of growing migration, and Section 6A was a legislative solution. Section 6A is one more statutory intervention in the long list of legislation that balances the humanitarian needs of migrants of Indian origin and the impact of such migration on the economic and cultural needs of the Indian states. Parliament, even before the enactment of the Citizenship Amendment Act 1995, has treated migration to the state of Assam as a cause of concern. Previous sections of this judgment trace the enactment of the Immigrants Expulsion from Assam Act 1950 and the IMDT Act, which dealt with the specific problem of undocumented migration to Assam. The central government could have extended the application of the IMDT Act to any other state by a notification. However, no such notification was issued indicating that the immigration to Assam presented the Union with a unique problem in terms of magnitude and impact. Though other states such as West Bengal, 2,216 kilometers, Meghalaya 443 kilometers, Tripura 856 kilometers, and Mizoram 318 kilometers share a larger border with Bangladesh as compared to Assam 263 kilometers, the magnitude of influx to Assam and its impact on the cultural and political rights of the Assamese and tribal populations is higher. The data submitted by the petitioners indicates that the total number of immigrants in Assam is approximately 40 lakhs, 57 lakhs in West Bengal, 30,000 in Meghalaya, and 3,25,000 in Tripura. The impact of 40 lakh migrants in Assam may conceivably greater than the impact of 57 lakh in migrants in West Bengal because of Assam's lesser population and land area compared to West Bengal. Thus, the singling out of Assam is based on rational considerations. Similarly, the cutoff date of 25th March 1971 is also rational. Even before the enactment of Section 6A, the IMDT Act defined an illegal immigrant as a person who entered India on or before 25 March 1971 without travel documents. As noted earlier, the IMDT Act was not specific in its application to Assam. The enactment defined the phrase illegal immigrant for all states, though the central government did not extend the provisions of the Act to other states. On 25 March 1971, the Pakistani army launched Operation Searchlight to curb the Bengali nationalist movement in East Pakistan. The migrants before the operation were considered to be migrants of partition towards which India had a liberal policy. Migrants from Bangladesh after the said date were considered to be migrants of war and not partition. Thus, the cutoff date of 25 March 1971 is reasonable. Having held that both the cutoff date and the singling out of Assam is based on rational considerations, the next question is whether the yardsticks have a rational nexus with the object of the provision. The answer is in the affirmative, since the migration from East Pakistan to Assam was in great numbers after the partition of undivided India, and since the migration from East Pakistan after Operation Searchlight would increase, the yardstick has nexus with the object of A, reducing migration, and B, conferring citizenship to migrants of Indian origin. Section 6A would be under-inclusive only when all those who are similarly situated with respect to the object and on the application of the rational yardstick are not included. Similarly, the provision would be over-inclusive only when those who are not similarly situated with respect to these two parameters are included. That not being the case, Section 6A is neither under-inclusive nor over-inclusive. Article 355 casts a duty on the Union of India to A, protect every state against external aggression, B, protect every state against internal disturbance, and C, ensure that the government of every state is carried out in accordance with the provisions of the Constitution. All these three phrases feature in Part 18 of the Constitution, which deals with emergency powers. If the duty of the Union to safeguard states against external aggression is justiciable in view of Article 355, then petitions could be filed claiming that the Union has not appropriately dealt with any of the situations referred to in Article 355. It could also be contended that emergency powers ought to have been invoked by the Union to deal with the situations appropriately. Reading the duty in Article 355 into a right would effectively place the emergency powers with citizens and courts. Such a consequence would be catastrophic for the federal structure of the Indian Constitution and would subjugate the constitutional status of states. Article 355 cannot be elevated as an independent ground of judicial review in view of the purpose of the provision as a justification clause and the impact of such a reading on the federal framework of the Constitution. As a matter of constitutional principle, the mere presence of different ethnic groups in a state is not sufficient to infringe the right guaranteed by Article 29(1). Article 29(1) confers the right to conserve, which means the right to take positive steps to protect culture and language. The petitioners ought to prove that the necessary effect of the law that promotes the presence of various ethnic groups in a state is that another ethnic group is unable to take steps to protect their culture or language. The petitioner also ought to prove that the inability to take steps to conserve culture or language is attributable to the mere presence of different groups. The detection of the foreigner is an elaborate process that required the state to build manpower and infrastructure for its implementation. The legislature conferred the state with the duty to implement the provision after it had built sufficient infrastructure for the same. The purpose of Section 6A3 was to
Visit ILMS Academy for various courses from contract drafting, RTI, labor law, GST, and more. Get certified to enhance employability.
was to provide a long-term solution to the issue of the large influx of migrants from Bangladesh to Assam. It is true that one of the causes of concern which led to the Assam students' movement and culminated with the Assam Accord was a dilution of the electoral right of those native to Assam because of the inflow of migrants. However, the purpose of Section 6A3 cannot be limited to it. The objective behind the enactment of the Citizenship Amendment Act 1985 was to deal with the larger problem of whether Bangladesh migrants of Indian origin could secure citizenship in India. The objective of the provision must be understood in the backdrop of the Indian policy on post-partition migration and the Assam movement. The principle of temporal unreasonableness cannot be applied to a situation where the classification is still relevant to the objective of the provision. The process of detection and conferring citizenship in Assam is a long drawn-out process spanning many decades. To strike it down due to lapse of time would be to ignore the context and object of the provision. Registration is not the de facto model of securing citizenship in India. The use of the deeming fiction in Section 6A2 obviates the need for registration. The provision does not contemplate a registration regime for persons who fall under this category, similar to Sections 3 and 4 of the Citizenship Act. Section 6A2 cannot be held unconstitutional for the only reason that it does not prescribe a process of registration. So I have also come to the conclusion that the provision is constitutional.
Speaking on behalf of myself and my brother Justices M.M. Sundresh and Justice Manoj Mishra, we have also upheld the constitutionality of Section 6A. We have, based upon the arguments, divided the issues which came for our consideration in two parts: prefatory issues and then the challenges regarding constitutionality. On prefatory issues, there were two objections raised on behalf of the respondents with regard to the maintainability of the very challenge. One was that the power of judicial review, whether it will extend to analyzing the constitutionality of Section 6A, and the second was that the writ petitions were barred by delay and laches. So far as these two preliminary objections are concerned, we didn't find any merit. Both we have turned down. Then on merits with regard to the constitutionality, we have formulated certain questions like: does Section 6A offend preambular values like fraternity? Is Section 6A ultra vires part 2 of the Constitution? Does Section 6A create an unreasonable classification which violates Article 14? Does Section 6A suffer from manifest arbitrariness? Does Section 6A violate the rights provided to indigenous communities under Article 29? Is Section 6A ultra vires Article 21 of the Constitution? Does Section 6A violates the political rights of the Indian citizens in Assam under Article 326? Does the operation of Section 6A causes external aggression and internal disturbance, culminating in the invocation of Article 355? Does the Citizenship Act conflict with provisions of the Immigration Expulsion from Assam Act 1950? And if so, how can the two legislations be harmoniously interpreted? And lastly, whether Section 6A violate international laws. While examining all these issues, as I said, the preliminary objections on judicial review and delay and laches we have turned down. On the question of fraternity, our conclusion is that in many ways the petitioners want fraternity to be interpreted in a highly restrictive manner, which allows them to choose their neighbors. Since this approach runs contrary to the very idea and ethos of the fraternity that was envisaged by the Constituent Assembly and as subsequently interpreted by this court, it cannot be accepted. Our reading of the Constitution and precedents is that fraternity requires people of different backgrounds and social circumstances to live and let live. The nomenclature of fraternity itself is self-explanatory to the extent that it exhibits the notion of inclusiveness and togetherness, as opposed to restricted applicability. Thus, it becomes imperative to refrain from employing this concept in a negative manner that selectively applies it to a particular segment while labeling another faction as illegal immigrants solely based on the alleged unconstitutionality of Section 6A. There is the other contention was that 6A violates Articles 6 and 7 of the Constitution of Part 2 that we have turned down, saying the petition's contention that 6A is unconstitutional as it prescribes different dates in comparison to Articles 6 and 7 cannot be accepted because Article 6 does not prohibit the granting of citizenship after the cut-off date of 19 July 1948. It only specifies the fulfillment of certain conditions which, as mentioned above, are also present in Section 6A, subclause 3. While Section 6A, clause 2 grants deemed citizenship without these conditions, the competence of Parliament to prescribe different conditions, which will be analyzed in detail in the later part, is well embedded in Article 11. Similarly, while Article 7 prohibits citizenship to people who re-migrated to India, this is only a subclass of people who have been granted citizenship by Section 6A. Since Section 6A grants citizenship even to people who migrated for the first time, the class of re-migrants is severable from this provision. As will be discussed in the following paragraphs, the Parliament was competent to specify different conditions for this subclass also. On the question whether the Parliament had the competence to specify different conditions under Article 11, we have upheld that power, that Parliament possessed the legislative power to lay down and specify different conditions, and such power is not controlled and regulated by Part 2 of the Constitution. The other contention raised was based upon the dual citizenship. That also has not found favor with us, and we have held. Therefore, based on the aforementioned reasons, we are of the considered opinion that the framework outlined by Section 6A is that an individual falling under Section 6A2 and 6A3 can only assert Indian citizenship. Such individuals are presumed to have relinquished their previous citizenship if authorities have reasons to believe that the previous citizenship is still being exercised. They are empowered under Section 9 of the Citizenship Act and associated rules to take steps to revoke the Indian citizenship of the delinquent individuals. Consequently, it can be deduced that the Section 6A does not contradict Section 9 of the Citizenship Act, and we declare so. On the question of violation of oath of allegiance, again, it did not find favor with us. We have said, moreover, the absence of such an oath does not absolve the immigrants from their obligation to respect the law and order of India, even when such oath is not taken before acquiring citizenship. Every citizen has to compulsorily abide by the norms of the Constitution, statutory laws, and other rules and regulations. We need not further emphasize that once the immigrants have become Indian citizens by operation of Section 6A, they are regulated by the Constitution of India, the laws framed under, and the values enshrined within them. Hence, the explicit lack of an oath of allegiance before the conferral of citizenship by Section 6A does not absolve the immigrants covered under this provision from following the laws of our country, just as any other citizen of India. On the question of Article 14, our conclusion is, as was discussed previously in paragraph 180 to 182 of this judgment, courts are generally tolerant of marginally under-inclusive legislations and recognize that similar cases may fall on both sides of the dividing line, provided that there is a broad discernible classification based on intelligible differentia. While analyzing validity under Article 14, the court has to be cognizant of the fact that any division done by a classification cannot be mathematically precise and accurate. As long as the broad purpose of the law is being fulfilled, a classification cannot be deemed unreasonable. We are thus of the considered opinion that even if there are states that could share similar characteristics with Assam, the comparison should be between two broad classes, Assam and the rest of India, rather than each individual constituent of these two classes. Since other states in general were not facing similar issues, the differentiation in classes was reasonable. On the point of manifest arbitrariness, we have divided in three parts. One is the argument was that cut-off date in Section 6A amounts to manifest arbitrariness. That we have not been able to accept, and we have held nevertheless. And as noted earlier, the determination of a cut-off date falls within the ambit of the policymakers, and the court would be reluctant to impinge into such fixation, save and except when the assigned date is vitiated with discriminatory and arbitrary considerations. Since the cut-off dates in Section 6A have been found not to offend the aforementioned principles, we are not inclined to interfere in the prescription of such cut-off dates. We may hasten to add here